So here I go on. What is redevelopment? I think all of us know demolishing an old building, building a new one. It's just previous try. Normally, when you have an existing flat or a commercial premises, normally the ratio is you get 1:1.3 as the extra area, which can come down to 1.25 or go up to 1.5, 1.6, but average about 1.3, depending on the negotiation skills and your commercial right of project. Keep that range in mind when you're negotiating your redevelopment project. And while going for redevelopment, also for added amenities and facilities which the developer offers to the old building. It's not only the exchange of flat, but also added amenities and facilities which come into the play. Now, there are many ways in which a developer could group the customers or the existing things. One is the design and layout which has been shown to the builder and road developer or to the society has not been complied with, and say that the BMC is not approved of it and therefore change it. Okay, that is something which we need to ensure that it does not happen. So if any changes have to be made, ensure that the builder takes a prior written consent before it's done into it. And that should be documented in the redevelopment agreement which is signed off with the builder. Okay, now as Vimalji has already mentioned, the society should be cautious with the builder who they're negotiating with. I mean, obviously the financial strength, and I think the Harshan also list out 16 factors as to what they should look at into a builder before agreeing to a builder coming on board with this concerned society. So the micro market, as you rightly mentioned, is very important. A builder like, I won't name them, but national level builder may not be very focused on micro market like Bandra or Chembur. But, there's even the Bombay micro market, the builders are specific into specific ward and specific thing. So I would prefer a society going to micro builder because they would know the system and get the things in place, other than go to national level player. Okay. Now, Vimalji also mentioned 77 and 79 bylaws of society and the Cooperative Society Act. That has to be complied with. Let's not feel that it's directly not legally complied with, has to be complied with. Okay. And bylaw number 77 of the society thing talks also about the structural audit, which I think my previous speakers have already spoken about. And depending on the structural audit, then only you can go in for redevelopment of the society. So that's the first document you need to get done before you go in for redevelopment of a society. I will not go into the details of it because I think the previous speakers have already discussed the same. So the advantages, some of the advantages which you see in a new building or redevelopment is in the building which comes up are obviously earthquake resistant. There is a corpus fund given to each member. There is an additional area of 25 to 30% and better planned and designed flats. Some of the other advantages which you see are modern facilities, amenities which come in the building like a society office, common clubhouse, pool, etc., etc. And also parking area. There's a lot of talk on the parking area. If you remember, there are two conflicting laws in Maharashtra right now. One is called the Maharashtra Ownership Flat Act and one is called RERA. Yes. Okay. Now under MOFA, car parking was under common area. It wasn't allotted to any specific flat owner. Under RERA and direction, not under RERA but under directions and circumscribed under RERA, car parking can be allotted to a specific thing and be sold also. Now, these are issues which we have to override and comply with. Okay? So, how many car parkings and whether the garage or not a garage? There's been a lot of talk previously when we had issues regarding open car parking, street parking, garage, semi-open, Remember, if it's a garage, it is FSI using or FS. If it's not a garage, it's free of FSI. Simple. Okay. So whenever you're buying a garage, obviously there could be an additional cost involved to it as opposed to any other thing because you're buying FSI. You're not buying a technically car parking space. Now the biggest disadvantage of redevelopment, if your redevelopment agreement has any lacuna on it, anything which you've missed out in a hurry, then you cannot repair it later. Okay? So, as a lawyer, and I act for quite a few builders in, when they're doing redevelopment projects, I tell the builder, please mention the old area which the member has and the proposed new area he or she is getting into the schedule of the agreement. Now, the developer is reluctant to do that, especially to mention the new area. Reason cost of stamp duty goes up.
Stamp duty, yeah.
Okay. Why bear that extra cost? So I have to sign that everything in. Now, the basic defect in doing that is that it becomes a title issue for the new owner. मैं 1000 square feet का 1300 square feet का मालिक कैसे बना? Is there any evidentiary documentary proof to show that? And remember, the Indian Registration Act, led by the Indian Evidence Act, is very clear. All immovable property documents have to be compulsory registered post 1808. Okay, so a lot of people come and tell me, sir, उस समय registration कौन कराता था? Registration होता था, and it will always happen. So please don't give us this ज्ञान कि registration उस वक्त होता नहीं था, and we have to have it registered. And please, people tell us कि sir, इतना cost बढ़ाना क्यों है? We manage to pass on the cost to the members and society. My thing is, I'd rather have a clear title of worth flat of 10 crores and spend a few lakhs rather than not spend that few lakhs and not have a clear title. Remember one thing, during the tenure of redevelopment, the members of the society do not have their own flats to stay in. So they are going to be moving outside their own homes and shifting to a temporary accommodation. So for that period, you enter into what we call a PAAA agreement. Okay, what we call permanent alternate accommodation agreement, which fructifies that for the tenure of staying outside the house, how much compensation you're being paid, it should be equivalent to the market rental value of around that area where you're going to stay, brokerage fees and shifting fees. Okay, because remember, a broker who's going to identify the flat who is going to charge his fees for that. There will be a legal access agreement executed, and there will be other incidental expenses. So you have to factor in all these expenses in that PAAA, including the new flat number and the new area which has been given to you. Now the challenge here is the PAAA technically cannot be entered into till the iodine CC has not been signed off. And why is that? Because the iodine CC will be received after the BMC has approved the plan. And when will the BMC approve the plan? After the redevelopment agreement is signed and the building is about to be broken down. So the chicken and egg situation. Okay? So therefore, the builder has to be of a repute, and we know that he or she or the company will not be running away with your flat. So that's what Vimalji said. Rather than going to an aggressive builder, we should go to a cautious builder who will reward you adequately and not make a dent in anybody else's financial situation. Okay, so that agreement then becomes an important document. So we as lawyers, what we tell the society members, get the PAAA signed and notarized at this point of time and have it registered once the RCC gets thing. So at least you have an evidentiary document in place on day one and not waiting for day 100 to get a registered document. Okay, so that is a check and balance, and the courts will approve of that. Okay, now obviously sometimes residential properties, when goes in for redevelopment, a major part of it gets converted to commercial or a mixed-use building. Okay, now the people then have to take a call whether they want to come back to that building or they want to sell off the flat to the builder and walk away. So at that time, it doesn't become a redevelopment agreement, it becomes a sale agreement. Okay, so there's a distinction out there. And quite a few times, I as a lawyer, if I'm advising society members, especially if it's a very small society of 10 to 15 or 20 members, we try to tell them, why don't you just sell and walk? Take the market price, builders can afford to pay that money, you walk, let the builder do what he or she wants to. You are secure on day one, you got your money, you can buy your flat wherever you want. You don't have to come back to the same place. And save some capital money also, in case you go to a flat which is cheaper in cost. Okay, now why we give that advice to smaller societies is, once the redevelopment happens and you get a larger area, right, then your property taxes goes high, right, and other incidental expenses go high. Society maintenance goes higher. If you have all these fanciful clubhouses and blah blah blah. So at times selling off is also a good option and going to a gated community or any other community which you might prefer. Okay. Now after structure audit, the second most important document after redevelopment is the consent of all the members. Even though the law is very clear that you require only 51% consent of the members to go ahead, if I'm acting in front of the builder, I always insist as close to 100%. For the simple reason, I'm not going to comply with the law itself. I don't want any errant member holding up my process subsequently. So for me, the clear-cut mandate to the builder is get 100% or as close to 100% before going ahead with the redevelopment agreement or the redevelopment of society. Only from the perspective that I don't want to remember tomorrow to create any hassles for me. He will become a hassle person in case the matter goes to court. I'm not saying the builder of the society will not win the matter, but for that interim period is a hassle which will increase the cost and everything else for the builder, which we don't want that to happen. Can a member change his consent? Yes, a member can change his consent subsequently. Okay, but that also has to be by giving a valid reason, and only if a builder or the developer is in default of any of the compliance work the builder is supposed to be doing. Otherwise, he or she cannot change his or her consent. Consent has to be on a 100 rupees stamp paper, duly signed and duly notarized. Okay, then what happens then? It's 100% fulfilled. And or sign the PAAA and get it duly notarized at that time, and not, if not registered before the IBC. Okay, as I said, a minority can definitely not stall the process, but can delay the process. Okay, because if he or she wants to go to court, the first ad interim order or the interim order the court will pass is stay the proceedings till we hear the full matter. Okay, and we know how effective the Indian judicial system is. It takes at least a few years to resolve the issue. So the idea is not to delay the process. That's why we insist on taking 100% consent before we go ahead with the matter. Okay. Now, we always advise, especially when there's a large society, and when I mean a large society, I mean 50 plus members, to form what we call a redevelopment committee. Because it's going to be difficult to coordinate with 50 to 60 members on a regular basis. So a redevelopment committee normally comprises of 5 to 7 members depending on the bandwidth of the members. And society should be able to appoint those redevelopment committee. It can be the management committee or a different committee also, who are easily available and accessible on both sides, to the builder and to the society members at large. to facilitate the communication between the builder and the society, so that there is no communication lag and there is transparency in the entire process. I will not go ahead into details of this. Okay. Now, for successful completion of a society redevelopment, we need quite a lot of documents. Okay. Some of them have already been spoken about by the previous speakers, but I'll try to highlight some of the documents which I feel are very important. One is obviously society registration certificate, the original building plan. Okay, because remember, people say carpet area, super built up area before era. Okay, built up area is 1300 square feet, carpet is 950. Say on what basis is your FSI is going to be calculated, on what basis your extra areas to be allotted on built up, super built up carpet area. There are with that very clear, everything is now on the carpet area. So the concept built up, super built up has now disappeared. So that's why we need the original building plan, so that we know exactly how much is the area allotted to you as per the original plan, approved plan. Because these days what we also seen is, the chhajja area has been taken inside the flat, the terrace area has been taken inside the flat. The so-called earlier, I remember about 8-10 years back, there was car parking allotted outside your flat with the limited car. That has been taken inside the flat. So all that area will be discarded, because that technically not carpet area. The title documents of the property, that includes the conveyance deed or the lease deed. Conveyance deed means you got a freehold land, lease deed means a leasehold land, depending on whether it's MMRDA, collector's land, or whatever kind of land which our previous speakers have been speaking about. Copy of the resolution of the special body, general body meeting regarding passing, approving the redevelopment society along with the proposal passed by the builder and accepted by the society. Okay. Assessment bill. The property assessment bill issued by a local municipal corporation has been duly paid to the full. Okay, that means your property tax, your water tax, and all the other municipal related taxes. Documents into a plot that includes a property card, TP card, the revenue document which earlier speakers have been talking about. Next time, 6-12, 7-12, search report to verify the title of each flat and each land and building. Title certificate issued by a lawyer, because that would need for RERA compliance work also. Index to updated, NA order if any, and the city survey plan. So all these are documents which are mandatorily required for starting and completing the redevelopment of a society. I've just listed it out properly. Up to point number 8 and 9 is what we need before the incorporation. Point number 10 onwards is when the builder steps in and proceeds with the redevelopment. I'll just take you through some of the documentation here. Approved building plan is approved by the society and the builder, which then gets ratified by the BNC with certain modification. IOD is intimation of disapproval. CC commences to allow you to commence construction. OC is when your building gets completed, and earlier speakers have already spoken about this. Completion certificates after that. Agreement for sale and appointment letters of the various consultants. Documents which you need pre-development. One is obviously from the builder's perspective and from the society members' perspective, a feasibility report of the redevelopment. How feasible is it and what should the members get should be clearly defined. Suggestions for members. Each member may want to get the flat customized to suit their own family taste, right? Some may want a 2 BHK with a puja room. Some may not want a puja room but want a study room. Some may want something else. So that little bit of customization, if can be incorporated in the plan, should be incorporated by the builder. Public notice for inviting tenders. Normally, society should give out a public notice inviting tenders to bid for the redevelopment and accept at least 3 or 4 quotations before they go ahead with any builder. Minutes of various meetings documenting how they evolved from one builder to next to the final plan, which has gone for approval. And that includes Section 79A approval under BCS. Obtaining permissions from the various municipal corporation, ULC and all. ULC technically is no longer applicable. However, it got repealed to 2000. However, some buildings are still under ULC, which needs to be rectified under the ULC order, which has not been complied with. Tender form, summary of the tenders received, and appointment letters of every operator. Okay. Now, some of the documents which you really need to prepare. One is a redevelopment agreement, which is the agreement between the society and the developer. Then the indemnity bond given by the developer. There's been Vilalji and one of the speakers talked about bank guarantee. Normally, society insists on a bank guarantee, and normally the builder is reluctant to give a bank guarantee because of cash flow issues. I mean, the kind of interest the bank gives is not the kind of profit which the builder is willing to make, and for him it's a loss. Let's be very honest about it. So there are alternatives to a bank guarantee which we return to the builder, which are normally acceptable to the society at large. With quite a few of my builder clients, we've given those decisions which have been accepted by the society, so we can discuss that on a case-to-case basis. Power authority from the society to the builder, that's a power of attorney, so that the builder can sign on behalf of society and doesn't have to get the society on the day-to-day procedural formalities. Agreement for audit documents as a PAAA, which I just discussed. Consent letters and MOU, that's it. These are basic documents which we really need to get the redevelopment process going. After the redevelopment is completed, right, and the process is over, you would need the possession letter from the builder to each of the members. Okay, and or application by new members to become members of the existing societies. Okay, otherwise, if they don't become members, technically the society is not going to recognize you as a member of the flat. Undertaking and resolution to admit the new members as new members with all their benefits. And the power of attorney which he gave to the builder at that time needs to be revoked and cancelled. Because once the procedure is over, we don't want the builder carrying any power of attorney on behalf of the society. Okay. Now some of the points to be noted. All the tenders which have been received should be objectively verified by the PMC consultant and or the architect to give a fair value assessment to the society, because society are not experts in these kind of matters. Okay, I mean, as previous speakers have said, just repeating point, track record, financial track record and completion project should be the criteria to choose a builder and not anything else. All agreements and documents, obviously, I'm not saying come to us, but please go to a competent lawyer of your choice who will scrutinize and advise you properly whether documents in order. Don't, I tell you, this is a fallacy which I see. When somebody is buying a home from a builder, a 100-page document or 200-page document is just given to you guys. Sir, यहाँ sign कर दो, ये salary भर दो, registration कर दो. How many of us actually read that document?
So they are one from that. They બધાનું થશે, મારું થશે.
Okay. Now, please don't do that with a redevelopment agreement. you're signing away your flat for a period of 3 to 4 years in exchange of hoping, I'm using the word hoping, to get a better flat 3 years or 4 years down the line. Correct? If that does not materialize, then what? Right? So please keep this fact in mind. Do not blindly just sign any document which has been passed on to you. Read it carefully, understand it, go to 10 hours if need be, but please read every word in document before you sign off here. Bank guarantee from a society perspective is essential. From a builder's perspective, we understand the financial outflow and things. The audience to that, which we can discuss on a case-to-case basis. Always insist on a penalty clause in the redevelopment agreement. I always insist on that, whether I'm acting for the builder or for the thing. And we always tell the builder, give an extended timeline in the redevelopment agreement. If you think you can complete the project in 3 years, put down 4 years. It doesn't do any harm. Even under the RERA registration, we propose the same thing. Please put in margin of 6 months to 1 year extra, completely done and hand it over. But don't delay the project beyond that. It should be as watertight and as close and shorter duration because you want to come back to home as quickly as possible. So in case of taking longer time, your P-AAA should be adequately well drafted to compensate you for that. So that's a permanent accommodation agreement which I discussed earlier. See, okay, let's understand the difference between DA and P-AAA. DA is between the society and the builder for the building of the entire land and the structure. P-AAA is the individual agreement between the member and the builder for the interim period and for his or her flat. Okay, interim period of 3 to 4 years when he's outside, how much compensation he's getting, and once he's coming back to the new apartment, what's the flat number, which floor, and what size of flat he's getting. So P-AAA is on a 1-to-1, which is obviously negotiated with the society at large, but signed and registered with the builder and the member directly, and the redevelopment agreement with the society and the builder. So there are two distinct agreements with two distinct parties, but read concurrently with each other.
Sir, if no society is there, leasehold plot is there, so it will be
No, even on leasehold property there are societies.
If there are no leaseholds, no society, only few members are staying in the building, 5-7 members. Then it will be each with each of them.
Then each individual member will have a separate. See, okay, let me just take a step back now. There are three kind of broadly. One will be when there's landlord tenants, where the landlord is going to be principal, secretary of redevelopment agreement, and tenants agree to it. Second is society redevelopment, and third is when the 3-4 members who bought a plot and have their own house. So in this, you're talking about a third case, when there are 4-5 members who bought their own land and building.
No, where there's a landlord and
when it's a landlord tenant, it's treated like a society and a member. The landlord becomes the society, the members become the tenants.
My name is Vimal Jain. Friends, neither I am an advocate nor an architect. Unfortunately, way back in 2011, I had become the victim in a redevelopment projects. To protect my lawful rights, I have to run from pillar to post. Due to the same, me and my family had to experience lots of unbearable pain in the whole legal battle. Today, I am what I have struggled and what I have experienced in my long legal journey. Ultimately, due to said incident, by profession, now I have become the building redevelopment consultant